Hello and welcome to this podcast, which is presented as part of the 2014 JPLC Oxford Joint Planning Law Conference in association with Landmark Chambers. The presentation will be in two parts, both dealing with the topic of housing land supply numbers. The first part will be presented by Stephen Whale, who is a member of Landmark Chambers and, as a member of the Attorney General's B panel, has been involved in many, if not most, of the leading cases that he discusses. The second part I will present. My name is Rupert Warren, QC, and I shall be dealing with some of the practical lessons that we can draw from inspectors' decisions and Secretary of State decisions grappling with this topic. The whole is aimed to last about an hour, and for those of you who need accreditation for your CPD points, questions can be found on the JPLC website.
The publication of the NPPF in March 2012 was in many respects supposed to simplify life. At a similar kind of time, the Supreme Court in the Tesco and Dundee judgment concluded that the interpretation of policy is a matter for the court. Now that case concerned strictly the interpretation of a development plan policy. It didn't take the courts long to adopt the same approach when it came to interpreting the NPPF. And there's been, as a consequence, already a considerable amount of litigation on the interpretation of aspects of the NPPF, and a raft of such cases even in the last year. And these have been cases not only in the High Court, but also in the Court of Appeal. And I want to look at some of these judgments. They concern, for example, paragraph 47, 49 and 14 and the interrelationship between the three. They concern the meaning of policies relevant for the supply of housing, Liverpool versus Sedgefield, and the presumption in favour of sustainable development. And the presentation will hopefully guide you through these judgments and their implications in practice. The first aspect of the NPPF to consider is perhaps paragraph 47, to boost significantly the supply of housing. That's the imperative, and it explains some of the things that local planning authorities should do. I've underlined here some of the salient parts of the paragraph. They're not, of course, underlined in the original, but I do that because those are some of the things I want to concentrate on in the course of this presentation. So, for example, the full objectively assessed needs for market and affordable housing. Secondly, deliverable sites. These are matters we'll return to in due course. I turn next, just by way of a reminder now, to paragraph 49 of the framework. Housing applications should be considered in the context of the presumption in favour of sustainable development. Plainly, this is a very important aspect of the framework, and for that reason I've underlined that text too. I'll return to this subject in due course. I'll also have a look in some detail at the next part of this paragraph, that is to say, relevant policies for the supply of housing and what that actually means according to the courts. One of the best known cases, if not the best known cases, that the courts have grappled with since the introduction of the NPPF is the Hunston Properties litigation. Put simply, there was an issue in the case before the inspector as to which figures to rely upon in terms of the housing requirement, and the inspector was faced with a choice. Firstly, she had the DCLG 2008 projections, and these indicated 688 new households per annum, and this was the most up-to-date evidence. The other option available to the inspector was the revoked RSS figure. This indicated only 360 units per annum, and it was a figure that reflected constraints in the district, those constraints being in particular the extensive green belt. Faced with that rather invidious choice, the inspector preferred to adopt the lower 360 units per annum figure. That is to say, a figure below the full objectively assessed needs figure. It was this conclusion of hers that led to the litigation. In the High Court upheld the challenge and concluded that the inspector had erred in law in relying upon this figure. The matter then went to the Court of Appeal, which upheld the conclusion of the High Court. The error, in short, was to use a figure below the full objectively assessed needs figure until such time as the local plan process had come up with a constrained figure. There was something of a sting in the tail in the Court of Appeal judgment, which has given some comfort to local planning authorities resisting development, or indeed others resisting development, because the Court of Appeal explained that constraints can come into play as part of the overall planning balance. So, for example, the lack of a 5-year housing land supply may carry little weight if it's inevitable that there will be such a shortfall given constraints in the area. And the court gave examples of these kinds of constraints: green belt, areas of outstanding natural beauty, or national parks. And secondly, the court explained that an adopted local plan can indeed fall short of meeting the full objectively assessed needs for housing in its area because of conflicts that might otherwise arise in terms of other policies or other designations. So in some respects, the Court of Appeal judgment, as I say, offers some comfort to opponents of development and was not in all respects all that the development industry might have hoped for. I mentioned next a postscript to the Hunston judgment, that is to say the judgment in the Gallagher Homes litigation. This was a challenge under Section 113 of the 2004 Act to the adoption of a local plan. And the court upheld the challenge, and at its root, the reason for the upholding of the challenge was the conclusion that the inspector, the examining inspector, had failed to deal with the issue of full objectively assessed housing need. He had not grappled with that assessment at the outset of his examination, and that there was a confusion of policy off housing needs with policy on housing requirement targets. The implication of the judgment is that, at the very least, authorities and examining inspectors ought to be mindful of and clear of the full objectively assessed housing need, at least as a starting point, if not necessarily the end point. As already mentioned, paragraph 49 of the NPPF is concerned with, amongst other things, relevant policies for the supply of housing. And the meaning of this phrase was one of the issues in the Cotswold District Council case. I've set out here the entirety of the particular policy that the court grappled with, that is to say policy 19 of the District Council's development plan. Mr. Justice Lewis's conclusion as to whether or not this particular policy was caught by paragraph 49 is set out at paragraph 72 of his judgment. And he concluded, in short, that this particular policy is a policy relating to the supply of housing, amongst other matters, in that it restricts development, including housing development. And therefore, he endorsed the inspector's conclusion, applying paragraph 49 of the framework, that local plan policy 19 should be disapplied to the extent that it seeks to restrict the supply of housing. This is important because if the council fails to have a 5-year housing land supply, this is one of the policies to be disapplied by reason of paragraph 49 of the framework. Similar issues arose in the South Northamptonshire litigation. 3 recent cases, all involving the same local authority, all bringing challenges to decisions by or on behalf of the Secretary of State. I refer to these as the South Northamptonshire Trilogy. For short, they can perhaps best be described as the Plummer case, the Barwood Homes case and the Barwood Land case, all decided towards the end of 2013 or in the early part of 2014. One of the policies under consideration in this litigation was South Northamptonshire's policy G2, which is a general strategy policy in Chapter 1 of the local plan. It's not in the housing chapter, which is in Chapter 2. And the policy explains that provision will be made for new development to be concentrated in a number of identified towns or places, and that new development will be limited in the villages and severely restrained in the open countryside. There's a conclusion at paragraph 34 in the Plummer judgment as to whether policy G2 is a housing supply policy within the meaning of paragraph 49. And in the court's judgment, it was so called. As the court explained, it applies to residential development and other forms of development, but to the extent that it seeks to restrict housing development and to concentrate it in a few identified places, it is on the Cotswold District Council's side of the line, a clear reference to the earlier Cotswold District Council judgment, and therefore falls within the scope of paragraph 49 of the framework. Again, and by way of a reminder, this means that it's a policy to be disapplied if the council doesn't have a 5-year housing land supply. Another policy under consideration in the litigation was policy EV2 of South Northamptonshire's local plan. This is not a housing chapter policy, nor is it in Chapter 1. Rather, it's a Chapter 4 environment policy. It explains that planning permission will not be granted for development in the open countryside, although exceptions may include, and a number are there set out. In the Barwood Land judgment, the court said the phraseology in the framework, paragraph 49, is either very narrow and specific, or alternatively, it requires a broader approach. And the full quotation there and the full point from paragraph 46 through to 48 is here set out. A separate issue, but an issue of interest nonetheless, is what has become of the regional spatial strategy and the evidence base for the regional spatial strategy once it or they have been revoked. The claimant's case in one of the South Northamptonshire cases was that given the revocation of the RSS, nothing could be relied upon in relation to it, even the evidence base for it prior to revocation. The court rejected that submission. The court concluded that the RSS is not, quote, expunged from history upon its revocation, and that even after revocation, an RSS figure or evidence base may still be relied upon to determine the full, objectively assessed housing needs for an area, and in other respects too. I'm bound to say that as more time passes after the RSSs have been revoked, increasingly they're not going to be able to be relied upon. Having looked at some policies that have been found by the courts to be caught by paragraph 49 of the framework, I now want to touch on an example of a policy that's been found not to be caught. The policy in question is policy E20, a green wedge policy in the North West Leicestershire local plan. This was the subject of consideration in the William Davis case, a case I'll come on to discuss for a different reason in due course. The policy is there set out, a policy in Chapter 4 of the particular local plan. At paragraph 47 of her judgment, Mrs Justice Lang concluded that Policy E20 does not relate to the supply of housing and therefore is not covered by paragraph 49 of the framework. This conclusion is alluded to at paragraph 47 of the Barwood Land judgment in the context of the discussion of Policy EV2. And I set out there the quotation from Mr Justice Ouseley, who distinguishes between very general policies and those designed to protect specific areas or features such as gaps. The next issue can be categorised as the Liverpool versus Sedgefield issue, and this is essentially, when determining the housing requirement, whether one seeks to deal with past undersupply in the early years of the plan, or perhaps spreads it throughout the entirety of the plan period, or perhaps even seeks to deal with it towards the end of the plan period. This was a matter discussed in the Bloor-Holmes litigation, and in this case, Mr Justice Lindblom concluded that neither method is prescribed or is said to be preferable to the other in the framework, and that in the circumstances the inspector was free to come to his own judgment. It is, though, worth noticing the more recent National Planning Practice Guidance, which poses the question, how should local planning authorities deal with past undersupply, and the guidance clearly indicates that local planning authorities should aim to deal with it within the first 5 years of the plan period, where possible. Paragraph 47 of the NPPF includes a footnote which begins to be considered deliverable. I just want to touch on the meaning of that word deliverable, at least insofar as the High Court is concerned. This was an issue in the Barrow-upon-Soar litigation. In that particular case, the inspector had taken the view that reliance could be placed upon the fact that the developer was an experienced developer which had the necessary financial resources to deal with the expense involved in any upgrading of the sewage system. There was in that case an issue as to the need to upgrade the sewage system in the area. And the court concluded that the inspector was entitled to place reliance upon that fact. Paragraph 47 of the framework moves on to paragraph 49, which by turn refers back by implication, if nothing else, to paragraph 14. And the interpretation of paragraph 14 of the framework has been a matter of great concern and great interest for those who work in this field, and came to be discussed in the William Davis judgment at paragraph 37. It's fair to say that this particular paragraph has proved to be somewhat controversial. In the case, as the paragraph suggests, the Secretary of State has submitted that paragraph 14 of the framework only applies to a scheme which has been found to be sustainable development, and that it would be contrary to the framework if the presumption in favour of development in paragraph 14 applied equally to both sustainable and non-sustainable development. Now that litigation has concluded, permission to appeal was sought, but permission to appeal was refused. In the light of the William Davis judgment, it was argued in the Dartford Borough Council case that before one applies the presumption in paragraph 14, one first of all has to come to a conclusion as to whether or not the proposed development in question is sustainable or not sustainable. Mrs Justice Patterson rejected that kind of approach, making it clear that there was no such prior conclusion to be reached, and her judgment, the salient part of it at paragraph 54, is here set out and merits close attention. What emerges from this particular paragraph is that the presumption in favour of sustainable development in paragraph 14 doesn't apply to non-sustainable development. What also emerges is that in order to evaluate whether proposed development is sustainable development, three considerations or three aspects have to be borne in mind. What also emerges is that there's not a clear and stark sequential approach to be adopted, but that the conclusion as to whether a proposal is sustainable development or not, in a sense, has to be undertaken or reached as part and parcel of the application of paragraph 14. This presentation has, I hope, helped you get up to speed with some of the recent developments in the courts in terms of the interpretation of the NPPF and particular aspects of it. There are bound to be others. There are bound to be many others. With the recent introduction of the NPPG, it's to be expected that this too will generate yet more litigation on the meaning of its particular paragraphs.
For the second part of this presentation, we turn to some practical issues concerned with the identification of the 5-year housing land supply. As Stephen said, it's crucial to understand the legal context for this because following the Supreme Court case in Tesco and Dundee, all matters concerned with the interpretation and application of the guidance, whether it's in the NPPF or the NPPG, could end up in the courts. But equally important is to understand how the Secretary of State and his inspectors are grappling with these issues on the ground every day, and that's the subject to which I will now turn. There are three areas which I'll deal with. The first concerns whether the housing requirement itself can be said to be up to date. The second concerns knottier issues of supply, including how one deals with the shortfall and the application of the Liverpool and Sedgefield methods. And thirdly, I'll deal briefly with the housing balance and how the planning inspectors and Secretary of States deal with the overall question in the context of deciding applications and appeals. The first point to make is that housing land supply is always an issue. That's because paragraph 47 of the NPPF, or the framework, applies when you're making a plan and at every stage thereafter. That's due to the rolling requirement on an annual basis that one finds in paragraph 47 and the effect of paragraph 49 of the framework. The date is usually taken at a base of the 1st of April before the exercise occurs. But it's very important to remember that this requirement applies all the time. Every day the local planning authority receives an application, it has to be able to demonstrate a 5-year supply of deliverable sites for housing. In that context, I shall look at the following practical aspects. The first is when a requirement is up to date by reference to the regional strategy, the local plan or the core strategy. The second is technical points on calculating the requirement. Then how to deal with any pre-existing shortfall. And finally, by way of some brief conclusions, the consequences of the 5-year housing land supply deficit. How does one know when a housing requirement is up to date? The first and easy point is that in a plan-making context, the issue simply doesn't arise. The point of the plan is to assess the current and future needs for the plan period. In other words, the premise of the plan-making process is that the figures are out of date or soon will be and need to be replaced. In many cases, the regional strategy figures have been revoked, and any saved policies or requirements are therefore very likely to be out of date. It depends on the degree of reliability of the regional strategy underlying evidence base. Now, the same may not be true for all aspects of the plan-making process. For instance, when part of the adopted plan is an allocations document which has been allocated after the NPPF, but works on the basis of older plan period housing requirements. That's a trickier situation, and one needs to look very carefully at the relationship between the allocations document, the core strategy, and the evidence that underlay the latter document. Paragraph 330 of the Planning Practice Guidance of March 2014 tells us that considerable weight should be given to the housing figures in adopted local plans, but it cautions against outdated evidence which may have underpinned those plans in the following terms. It should be borne in mind that evidence which dates back several years, such as that drawn from revoked regional strategies, may not adequately reflect current needs. Following from Stevens' paper, that chimes with the court's guidance in the Gallagher and the South Northamptonshire cases. The evidence base which underlay the regional strategy and some core strategies is not expunged, but needs to be carefully assessed and used with great caution. Picking up the point about the use of adopted documents, I turn to two cases, the first a High Court decision, the second a decision by an inspector. In Gladman Homes Limited and Wokingham Borough Council, a decision of July 2014, the High Court held as follows. It isn't for inspectors sitting on allocations development plan documents to determine whether the underlying housing requirement is too low. The reason being that that exercise is not one which is required by the statute, which seeks simply conformity with the earlier document, which is usually the core strategy at the moment. That conformity stems from the requirements of Regulation 8.4. Secondly, it's not an exercise which is required by the framework itself. There's no requirement in that document to revisit housing numbers which are in allocated core strategies. Indeed, the practical issue which arises in almost all these cases is that revisiting all of the underlying figures would probably lead to the halting of the development plan process and consequent delay in adopting sites and therefore in the delivery of new housing, which after all is the central focus of the government's planning policy. The inspector's decision, which is of most relevance on this topic at the moment, is the Gibbons Lane decision of the 8th of July 2014. That was an appeal which took place in the Bracknell Forest area. The factual background was as follows. The core strategy in Bracknell Forest was adopted in February 2008. The allocations document, called the SALP, was adopted in November 2014. So both of those documents formed the development plan for the purposes of the appeal which took place in July 2014. The Council relied on the recent allocations document, the SALP, as establishing that the relevant housing requirement was as set out in the core strategy, endorsed, as they put it, by the allocations inspector and by the adoption of that document, the SALP. The inspector on the appeal rejected that argument, and I draw your attention in particular to paragraphs 9 to 11 of his decision letter. He had a full, objectively assessed need assessment from the appellant to rely on, but he found that the SALP could not be relied on in this way. I want to turn to the precise reasoning in the Gibbons Lane decision in paragraphs 10 to 11. This is what the inspector found. More importantly, while the council might well have been able to demonstrate a 5-year supply of deliverable housing sites in April 2013, as recorded by the inspector in June 2013, it does not follow that it can continue to do so in March 2014. Circumstances can change with the passing of time. Notwithstanding the council's reference to conversions from office space to dwellings underway in Bracknell itself, the comprehensive analysis produced by the appellant in the lead-up to and in updated form at the hearing show conclusively that the council cannot demonstrate a 5-year supply of deliverable housing sites at the date of the hearing. In particular, it's evident from the appellant's analyses that the trajectory of delivery relied upon by the council and accepted by the SALP inspector has turned out to be optimistic. And that was a finding which reflected paragraph 12 of the inspector's report on the SALP, where he rejected a request by many parties to that process to reopen the housing requirement figures found in the core strategy. The Bracknell example is a good way to deal with the derivation of housing figures where the regional strategy lies in the background. Many adopted housing requirements are derived from now revoked regional figures. In the Bracknell example, the adopted housing requirement to 2021, found in the core strategy, comes from the draft South East Plan. Now, plainly, it is open to objection on the grounds of age, the fact that the South East Plan after the panel report was adopted with a significantly higher housing target for Bracknell than in the draft version, nearly 2,500 units more, and finally, because of the change in housing policy brought about in the framework of March 2012. It's therefore a good example of how one needs to look carefully at the exact derivation of core strategy housing figures when seeing whether a later allocations document can be relied on as the starting point for an assessment of housing need now. A further interesting example of this topic is the decision of an inspector in the Swanley case. The decision is dated the 23rd of January 2014, and this is the key finding of the inspector. The core strategy was formulated prior to the guidance in the framework coming into the decision-making process. There is a difference between the approaches to the formulation of housing targets from when the core strategy targets were decided and now with the framework. Previous advice in Planning Policy Statement 3 required provision of a sufficient quantity of housing taking into account need and demand. The framework indicates that local planning authorities should use their evidence base to ensure that their local plan meets the full, objectively assessed needs for market and affordable housing in the housing market area. The emphasis has changed in the framework, and in my view, this is an important material consideration. My attention has not been drawn to any objectively assessed needs assessment produced since the core strategy. The framework also notes that housing applications should be considered in the context of the presumption in favour of sustainable development. The approach in the Gibbons Lane and the Swanley decisions chimes with the law as expressed in Gallagher Holmes, to which Stephen has referred. That is a judgment dated the 30th of March 2014, and I remind you of its terms now that we've seen some examples of this issue playing out at the appeal level. In plan making, the court held, full objectively assessed needs are, to quote the judge, not only a material consideration, but a consideration of particular standing. It's insufficient, the court went on to hold, to determine the maximum supply available and constrain needs to that level. Thirdly, using earlier policy, for instance the regional strategy, even as a starting point, should be done only with extreme caution, according to the court, because of the radical change in respect of housing policy affected by the NPPF. That third point, it seems to me, is one which has crucial relevance for daily practice in this area. Finally, the Hunston two-stage approach referred to by Stephen was relevant to plan making. The full objectively assessed needs first, then other considerations going to greater or lesser levels of constraint of that figure. Turning to current issues in relation to the calculation of the phone or full objectively assessed need, I draw your attention to the following points in particular. Firstly, the use of the CLG household projections are the starting point. The PPG at paragraph 330 says, where there is no robust recent assessment of full housing needs. However, the CLG household projection figures are expressly not housing needs assessments. That point is made clear within the CLG document itself at page 2, and it's also mentioned in the 2011 based interim projections and in PPG paragraph 2A 15. The last full CLG household projections are those for the 2008 base, which were published in 2010. A practical issue which arises daily is that those 2011 figures only run to 2021, and therefore for plan periods to 2026 and 2031, in other words, all plans that are currently being considered, they must be extrapolated. They are interim because they are only partially reflective of the data within the 2011 census, which was published in 2013. Finally, there are internal issues with the reliability of the 2011 household projections, particularly in relation to the birth rates which are assumed. One can see more detailed assessment of that particular fallibility of the document within the methodology document published by CLG itself. Examination of the household projections by CLG has also revealed that they are subject to fallibilities relating to underlying household formation rates, or what are sometimes called headship rates. That is the way in which household projections are extrapolated from population increases. They have been suppressed, it has been found, by the undersupply of housing or by the worsening affordability of housing across the country. The CLG household projections are also, of course, based on ONS, Office for National Statistics data. That data has been updated since the 2011 CLG projections and shows lower population growth. However, the ONS data is itself questionable because it may be substantially affected by the recession and therefore not provide a reliable guide to future trends, a point which is noted in the March 2014 PPG at paragraph 2A 15. The new CLG data is due in December 2014. In many cases, the assessment of the full objectively assessed need has been based on proprietary software which has been used by or on behalf of local planning authorities. That proprietary software, of which there are many different varieties, usually seeks to model different scenarios of need on different bases. One of the most common in use is the POP Group suite of software. There are two main areas of concern with these packages which have emerged through their examination in EIP hearings and at Section 78 appeals. Firstly, they are not transparent and are very difficult as a consequence to rely on as demonstrating a particular level of need. And demonstration, of course, is part of the policy test for full objectively assessed needs. A good example, perhaps, to track in future months is that relating to the Uttlesford Local Plan examination in public, which is taking place in November and December 2014. The Inspector Ray Foster's conclusions and his interim findings will be a good guide to how this particular topic is being considered by the Inspectorate at the moment. The second main area of concern is the prioritisation within those documents of internal coherence and consistency with the ONS data over local verisimilitude. In other words, they seek to present a statistically coherent picture without necessarily focusing on whether that picture matches the local conditions on the ground. To recap then on matters concerning the housing requirement aspects of this issue. An up-to-date local plan requirement is a strong starting point. Whether a local plan is up to date is a matter of judgment. Regional strategy-derived local plan targets are, however, likely to fail that test. Allocations documents which simply seek to reflect earlier core strategy requirements may not be robust indicators of current need. Where there is no robust up-to-date assessment, the CLG household predictions should be used, but only as a starting point. They should be used with caution and subject to the various adjustments suggested in the PPG. A good commentary on these issues can be found in the PAS and PBA document of June 2014, which is called the Technical Advice Note and can be found on the PAS website. How does one deal in these calculations with the shortfall in the provision of housing over the past few years? In many cases, the treatment of the existing shortfall will make the difference between establishing a 5-year housing land supply and failing to do so. The shortfall is a different point from the issue which arises from paragraph 47 of the framework of persistent under-delivery. Obviously, there's an overlap between the two, but they are separate when one is approaching this in terms of methodology. If there is a shortfall from the beginning of the planned period to the point at which the 5-year assessment is being undertaken, there's little controversy over the need to make that shortfall up as a matter of principle. But much more difficult is the shortfall which may exist as at the beginning of a new plan period. This is what the government tells us about that subject in paragraph 325 of the March 2014 practice guidance. Under the heading "How should local planning authorities deal with past undersupply of housing?" we are told, local planning authorities should aim to deal with any undersupply within the first 5 years of the plan period where possible. Where this cannot be met in the first 5 years, local planning authorities will need to work with neighbouring authorities under the duty to cooperate. What though should one make of the guidance that the government gives us in paragraph 335? It is primarily aimed at plan making rather than decision taking. The reference to meeting any undersupply in the first 5 years of the plan doesn't make sense in many cases where those first 5 years have already elapsed by the time of the assessment which you are undertaking. The reference to the duty to cooperate is similarly a reference to the plan-making rather than decision-taking process. As a consequence, the guidance has been applied to full objectively assessed need exercises. A good example is in the Cody Road Waterbeach decision at paragraph 29. That means that in a full objectively assessed need exercise, the extent of existing shortfall, even before the plan period, is relevant. How much shortfall, though, should be taken into account? Well, that will depend on the evidence. It will usually be difficult to go back more than a few years before the plan period because of evidential difficulties. However, for plans starting in 2011, undersupply throughout the period since 2000 ought to be relevant and ascertainable. I should mention that in paragraphs 532 to 534 of the PAS document to which I've referred, June 2014, there is a query raised as to whether pre-plan shortfall should in fact be met in the way that the Cody Road decision indicates. There's no indication at the moment whether that advice has been endorsed by CLG. I turn now to the debate on how to meet that shortfall, what tends to be called the Liverpool and Sedgefield debate. If there is an identified shortfall, the question is, over what period should that be met? Should it be met all within the first 5 years, and therefore become relevant to the full objectively assessed assessment of the 5-year housing land supply? That's the Sedgefield approach. Or should it be spread out over the remainder of the plan period, the Liverpool method, which is also known as the trajectory approach? There is no absolute rule in answer to that question. In Bloor, Holmes and the Secretary of State, Mr. Justice Lindblom commented that both are well-known and well-tried ways to deal with the shortfall. This is what he said. Neither method is prescribed or said to be preferable to the other in government policy in the NPPF. In my view, the inspector was free to come to his own judgment on this question. In paragraphs 7 and 8 of his decision letter, he referred to the essential characteristics of each method. In paragraph 7, he said the Liverpool method spreads any shortfall in supply in a given year over the remainder of the plan period and is an appropriate method to adopt where there is not a severe shortage in supply. In paragraph 8, he described the Sedgefield approach as one that seeks to meet any shortfall earlier in the plan period, and he acknowledged Bloor's assertion that this approach accords with the imperative of significantly boosting the supply of housing stated in paragraph 47 of the NPPF. To add a comment, one notes there that part of the justification for the Liverpool method was where there is not a severe shortage in supply, which plainly, in a particular case, will be a matter of judgment. However, with paragraph 335 of the practice guidance and various pronouncements in appeal decisions, it has been clearly established that the Sedgefield approach better accords with the National Planning Policy Framework, paragraph 47. I give you as another example the decision by the Secretary of State in the Shottery Stratford-upon-Avon decision, paragraph 14 of the decision letter approving the inspector's report at paragraph 497. However, there continue to be cases where the Liverpool approach is preferred. As the Bloor-Holmes case indicates, these tend to be cases where there is a structural reason related to the delivery of new housing which would make the requirement of meeting shortfall within 5 years inappropriate. I give you 3 examples of this in practice. The first example is the Blaby decision. The core strategy was adopted in that case in February 2013. The appeal was heard on the 12th of July 2013 with a decision on the 1st of August. The core strategy in that case had taken a Liverpool approach in the context of a housing requirement to be met in large part by a very large urban extension delivering units towards the end of the plan period. In paragraph 10 of the decision, the inspector said this: taking account of the recent date of the examination and adoption of the core strategy, it would be premature to take a different approach to housing supply than that taken in the examination inspector's report. Furthermore, that report considered that further flexibility is given by the housing trajectory, not including an allowance for windfall sites. The second example is the recent decision in the Lymm Airfield case. The decision was on the 29th of July 2014, with the hearing a few days before. The core strategy in that case had been adopted in September 2013. The core strategy included pre-plan shortfall dealt with by the Liverpool approach. One can find that in paragraph 16 of the decision letter. The Liverpool approach was preferred in the phone calculation, and these were the reasons for that conclusion. The core strategy inspector did not have the benefit of the advice in the planning practice guidance, but he would have been aware of the different methodologies and that Sedgefield is the one that best accords with framework policy. The fact that the core strategy has been found sound so recently and that the Liverpool approach was integral to the requirement on which it was based is a matter of considerable weight. Whilst I come to a different view from the core strategy inspector on the buffer, that is because there's been a material change in circumstance. In relation to the methodology to be applied to dealing with a shortfall, there's no prescription as to the approach. It would not be in the interest of good planning or consistency to cast doubt on the core strategy inspector's judgment. The third and final example I give you is from a Section 78 appeal in Bracknell relating to a site in Binfield. The appeal is due to be determined in early 2015. The core strategy requirement dates to 2008. The allocations document, the SALP, was adopted in 2013 and adopted the Liverpool approach for the following reasons. Both calculation methods, said the inspector, have advantages and drawbacks. In the present case, it's clear that the SALP's delivery structure involves larger sites that will require significant supporting infrastructure and that are likely to come forward at generally later stages during the plan period. Seeking to meet the outstanding shortfall during a 5-year period would be inconsistent with that approach. Moreover, it would require an even greater rate of housing delivery during the first 5-year period than is shown in the present trajectory. Projected completions during some of these years already markedly exceed recent delivery rates. It would be unrealistic to expect an even higher rate to be achieved. So, drawing some conclusions from those practical examples of the Liverpool and Sedgefield debate. Sedgefield should be the presumption, but there will be circumstances in which the Liverpool approach might be justified. Firstly, where the shortfall is not great. Secondly, where an up-to-date recent housing requirement and trajectory was reached on that basis. Thirdly, where housing delivery in an adopted plan depends on substantial sites delivering late in the plan period. And fourthly, where delivery rates associated with meeting the shortfall would be unrealistic. In terms of overall conclusions, then, the first question is always whether the existing assessment, wherever it is in a core strategy or a local plan, is up to date. If it is, then it will usually provide the answers. If it is not, then requirements will need to be calculated using locally adjusted household projection figures produced by CLG, subject no doubt to yet further methodological arguments over the forthcoming December 2014 set of data. In terms of shortfall, Sedgefield will be the starting point, but there will remain cases where, exceptionally, Liverpool is the more appropriate approach to meeting the shortfall. So in conclusion, there are a number of technical issues which, as you've seen, bedevil this topic on a daily basis. I think perhaps going forward over the next year or two, the main ones will continue to centre on how difficult it is to understand whether the housing requirement in a particular case can be said to be up to date, that continuing uncertainty over the status of evidence that lay behind the now revoked regional strategy, and matters to do with the Liverpool and Sedgefield debate, which, as the cases which I've shown you indicate, isn't going away anytime soon. I'd like to draw, in final conclusion, some broader points about the way that housing land supply is dealt with in the overall planning balance, by reference to two particular cases. The first is the Fox Land and Properties case at Fundersley in Essex. Now, you may remember that that was a case where there was hardly any housing land supply, under a year overall. And yet the Secretary of State refused permission on the basis of the impact that that development would have on the Greenbelt and countryside. So even a cast iron case on housing land supply can't guarantee a positive outcome for the developer. The other case which I'd like to mention to you briefly is the plan-making case of Grand Union Investments and Dacorum Borough Council. Now, that was a case in which the disappointed promoter of land challenged the adoption of a local development document on the basis that its housing land supply calculations were wrong and contrary to the NPPF. In particular, the conclusion of the inspector that despite real difficulties with the way that housing land supply had been calculated and dealt with in that case, nonetheless it was better to have a plan than no plan at all, And that was particularly so, he found, where there could be an early review of the plan. Now, the disappointed promoters of the land unsuccessfully challenged the decision on the basis that this was in essence a binary consideration. Either the plan was sound or it was not sound, and the fudge, as they put it to the court, wasn't something that the 2004 Act contemplated. Mr. Justice Lindblom, rejecting that challenge, held that there was perfectly adequate reasoning for the early review approach, and so the challenge failed. So even in a plan-making context, one can see that a cast-iron housing land case which is accepted by an inspector won't necessarily be enough to guarantee a positive outcome for your clients. Bearing all of this in mind, two important lessons I think emerge. The first is not to take any of the published data necessarily for granted. At the plan-making stage and also at the 5-year housing land supply stage, a root and branch reappraisal must be undertaken. The second is never to become too obsessed with housing land supply as the overall answer to the particular problem. These are issues which arise in the context of the NPPF as a whole and should always be seen as such.